she should have the physician certificate of medical examination there on file if you will take judicial notice of that.
The court notes that it has received a certificate of medical examination from Dr. McPherson. Mr. Hammett, do you have any objections?
No objection, Your Honor.
So noted. Thank you.
Okay. And so the doctor has stated that your mother is incapacitated, totally incapacitated. Is that correct?
Correct.
Okay. And so at this time, you do have the medical and statutory durable power of attorney. Is that correct?
Correct.
However, with those, you are not able to essentially have superior authority to Susan. So if she asks or tries to do something that would be contrary to her best interest, then she is legally allowed to do that. Is that correct?
Correct.
And so is the reason that we are applying for guardianship to essentially make sure that as this progresses, that you are able to protect her from potentially poor judgment as this progresses.
Correct.
Okay. And so regarding what she owns, she has 1/2 interest in the community estate, with that community estate being approximately $160,000. Is that correct?
Correct.
And that community estate would be between her and her husband, Michael. Is that right?
Correct.
Okay. And so you're asking the court to appoint you as the guardian so that you are able to manage those funds. Is that correct?
Correct.
At this time, currently, if she did ask you for that money to go out and buy herself a brand new Corvette, legally, you would have to give her that money. Is that correct?
That is correct.
And so you're asking this court to give you the permission to have the authority to tell her, no, you don't need that Corvette if you are to do such.
I don't even want a Corvette.
Okay, well, good.
You want the red one.
Okay, is that correct?
That is correct.
All right. And so regarding the family, and I guess we should clarify, you consider Susan your mother, is that correct?
That is correct.
Okay, but she is not your biological mother, is that right?
Correct.
Susan was married to
My
your father, your biological father. So she was your stepmother until that divorce, is that correct?
that is correct.
And then Susan has since remarried to Michael. So it is essentially your stepmother and stepfather that are both married. Is that correct? Okay. And so regarding her family, both of her parents have passed away. Is that correct?
Yes.
Okay. And then as far as biological children, she did not have any biological children, correct?
Correct.
She did not adopt any children, correct?
Correct.
Okay. She does have a spouse, and that is Mr. Michael Malloy, and he is here today. Is that right?
Yes.
And we did have a CME on him to see if we needed to have 2 guardianships, but at this time, the doctor stated that he is partially incapacitated. Is that correct?
Yes.
And so we have not had him sign a waiver. However, Judge, I do have him here if you would like to have him basically state that he has received notice and has no objection, that sort of thing, entering his appearance.
Thank you. You can continue. If we need it, we'll come back to it.
Thanks, Judge.
We do need it?
We can get to that in a bit.
Okay.
Okay. Then we also have, she has one sister, Janice Boer. Is that correct?
Yes.
And to the best of your knowledge, Janice Boer no longer has the capacity to sign or execute documents. Is that right?
That is correct.
And she is up in Illinois. Is that right?
Yes.
Okay. And she is, have you talked to her about this?
I have not, but her daughter, whose name is also Tammy, has, and Mom spoke with Tammy this morning.
Okay. And does she have the ability to either file an objection or to serve as the guardian, Janice? Does she have the mental ability?
No.
Okay.
No.
Okay. Okay. And then we initially had the Ventura Place administrator who was listed here, but she is no longer a resident of Ventura Place. Is that correct?
Correct.
Okay. So she is now at McKenzie Place, right? All right. And have you spoken with the staff at McKenzie Place?
I don't recall if I have. I think Lisa knows, but we have not. Lisa was in Paris at the time, so when all this was going on, she just came back. I know we've briefly spoken, but
okay. And you did speak to Tammy at
yes.
Ventura
Tammy
previously.
Everything.
Okay. All right. Then your mother was served with the application for guardianship shortly after it was filed. Is that correct?
Correct.
Okay. And as we addressed, you are the stepdaughter, even if that is legally no longer the case. That is what you refer to yourself as. Is that correct? or daughter?
Daughter.
Daughter. Okay. So
She's
you are
been my mom for 45 years.
okay. So you have considered her your mother, and
Yes.
step is not necessary then. Is that correct?
That is correct.
All right then. And so, as we stated, she is incapacitated and requires a guardian of the person and estate. And so you're asking this court to appoint you as the guardian of the person and estate to have all authority and powers that are listed here in the application and listed in the Texas Estates Code. Is that correct?
Correct.
And so you understand that as the guardian of her person and estate, you will have the duty to do what is in her best interest, whether that be making medical decisions, residential decisions, financial matters, that sort of thing. Is that correct?
Correct.
Okay. And you understand that you are not able to commit her to any sort of inpatient mental hospital, anything along those lines that requires a court order.
Correct.
All right, then. And regarding your qualifications, is that good news, Susan?
Yeah, good news.
Okay, well, I'm glad to hear that. All right. And as far as your qualification, you are not disqualified from serving as the guardian. Is that correct?
Yes.
Okay. You are a capable person. You have capacity. Is that right?
Yes.
Your employment. So you are a veteran of the Air Force. Is that correct?
Correct.
Okay. And who do you currently work for?
I actually work for myself. I'm a marketing executive.
Okay. And do you also still work in some sort of veterans or other capacity there, or work with them?
I volunteer
Okay.
a lot.
Okay.
Within the community. Yes.
Okay. So regarding your criminal history or hopefully lack thereof, I don't know, Judge, have you gotten her fingerprints back yet?
No, sir, I have not. I know that the fingerprint
Yeah.
was obtained on Monday, but I have not received that back. So
Yes, sir.
let me just kind of briefly interrupt you since we
Sure.
knew that this was coming. You're going to testify to your criminal history.
Okay.
I don't have your criminal history in front of me, like what we usually do. I'm willing to go ahead and go forward. But I just want to remind you again of your oath to tell the truth and the whole truth and nothing but the truth.
Okay.
So if you will please remember your oath for under the next few questions that Mr.
Okay.
Norman has for you. Mr. Norman, please proceed.
Okay. Have you ever been convicted of a misdemeanor?
No.
Okay. Have you ever been convicted of a felony?
No.
Are there any pending felonies or misdemeanors that are currently being charged against you?
No.
Have you ever been found to have committed abuse by Children's Protective Services?
No.
Have you ever been found to have committed abuse by Adult Protective Services?
No.
Okay. All right. And is there any sort of conflict of interest that would make it inappropriate for you to serve as Susan's guardian, such as owing them money or having some sort of adverse interest to them?
No.
Okay. And you are not a notoriously bad person. Is that correct?
No.
Okay. And in fact, you are a family friend of Miss Kristen Vanderplas Lafreniere. Is that
Oh,
correct?
yes.
Okay.
Yes.
And hopefully, I know the judge knows her. That would provide a little bit of credibility for you there.
Yes,
Okay.
definitely.
All right, then.
I was just chatting with her last night.
Well, good. All right. And you are asking the court to appoint you as the guardian of the person and the state so that you can essentially help your mother as you have been, but with the authority you need to protect her in the future and as she is now, correct?
Correct.
All right, then. Judge, I will pass this witness.
Thank you. All right, Mr. Hammett.
Thank you, Judge. Ma'am, my name's Ryan Hammett. You understand that the court has appointed me to represent Susan in this case, correct?
Correct.
Just a moment ago, when Mr. Norman asked you about Susan's estate, I believe that you said that the total between Susan and her husband was approximately $160,000. Is that correct?
Correct. And that's an estimate, guesstimate.
Oh. Okay. I want, if you could, since you've been the agent under her statutory durable power of attorney for a while, I want you to divide that up or go into a little bit more detail if you can. Can you tell us as of right now how much money she has in bank accounts, if you know that?
I could look that up for you. I'm going to guess about 120,000, maybe 140,000.
So 120 to 140 just cash in bank accounts, is that correct?
Yes, yes.
Okay. And then does she have any retirement? Does she have any
No,
brokerage account, anything like that?
that was everything. That
Okay.
included their account, to my knowledge, didn't we include?
I believe, yes.
Yeah.
That's, you give me 106 and then the.
Oh, okay. Okay.
Okay.
And then we did the 50, I'm reading it now, 50,000 for the year. Yeah.
Is that okay? Is that accurate? Does she and her husband together receive about $4,200 a month in
Correct.
Social Security? Okay. That's not just her. That's both of them.
No, that's both of them. They're on a
Okay.
very limited income.
Got it. So we have 140,000 approximately cash in banks, 50,000 a year in Social Security income. Is that correct?
Yes.
Okay. Does she receive income from anywhere else other than Social Security on a monthly basis?
No,
No other source of revenue on a yearly basis either. Is that right?
that is correct.
Okay. Does she own any real estate?
No,
Okay. Does she own any vehicles?
no,
Does she have any other personal property besides vehicles and bank accounts that has any significant value?
she has jewelry, and we've been told that we need to do an inventory of that. But at this
Okay.
moment, I have no idea what it's worth.
Is it substantial, or is it something just a few odds and ends like wedding ring?
She has a wedding ring. To be honest with you, it was boxed up in Arizona, and she doesn't even remember where it's at right now. And I am still looking for things. She does have a lot of costume type jewelry. So it was recommended, I believe, by maybe the court inspector to value it at about maybe 1,000.
Very good. Is that then a description that you've given of all of her estate? We're not leaving anything out. Is that correct?
Well, they have furniture and things
Sure.
like that, antiques.
But those items don't have a substantial value on their own. Is that correct?
No, that is correct.
Okay. We haven't left anything out though.
Not that I'm aware of.
Fair enough. Now about Susan specifically, the judge has been able to tell from Susan chiming in that she's still well able to communicate and she's well able to make her opinions known. Is that correct?
Definitely.
And is not afraid to do so. Is that right?
Definitely.
Okay. Have you had the opportunity to visit with Susan about the guardianship on one or more occasions?
Yes.
Okay. And has she expressed to you any objection to you serving as her guardian?
She hasn't expressed any objection because of the way I've explained it to her and the fact that it's mainly to protect the funds that are still there, which is very few. And the fact that they are young people still, I consider them young people. They're 72 and 68. And they've only got basically the 145,000 in cash, and then they get the 50,000 a year. So I'm very concerned, considering that their rent is close to 7,400 a month.
Let me say this then, or ask you this question. You know that I visited with Susan, correct?
Correct.
And I'll represent to you that in my communication or my conversations with Susan, that she expressed some concern that she still be able to give her input in decisions that are made. Is that something that you would expect her to have said, knowing Susan?
Yes.
Okay. As the guardian, can you represent to the judge, if he appoints you, that is, that you will continue to involve Susan in any decision that's made regarding her care and also her finances, to the extent, of course, that that decision is in her best interest?
Yes, I will definitely, excuse me, definitely include my mom. I have always included mom and dad. I have a finance binder and we go through their finances. Mom has a tendency not to really understand what the outgo is compared to what the income coming in.
Understand, but if she has an opinion regarding her care or her finances, you will continue to involve her in those decisions.
Yes.
And keep her up to speed with what's going on, both with her care and
Yes.
her finances. Is that
Yes.
correct? And
Yes.
you understand as a guardian that you actually have that duty to make sure that you maintain her as independently as she can handle, correct?
Correct.
Very good. I'll pass the witness, Judge.
Mr. Norman, do you wish to follow with anything?
Judge, I don't believe any follow-ups necessary.
All right. Mr. Norman, any further witnesses?
Let's go ahead and we'll have Michael come up and he can give his approval if he feels so inclined. There you go. Well, Michael, actually, you know what? Why don't I come sit next to you, okay?
Oh, okay.
Let's do that. All right. Rather than making him get up from this couch that we got here. All right. We can go ahead and I'll call Michael Malloy as the next witness.
All right, Mr. Malloy, as you heard, we're doing this by Zoom, but I do need to place you under oath before you testify. Do you solemnly swear that the testimony that you're about to give in the matter before this court is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, thank you. All right. Mr. Norman, you may
Thank you,
begin.
Judge. All right. Would you please state your name for the record?
My name is Michael Joseph Malloy.
Okay. And Michael, you are married to Susan Malloy. Is that correct?
Correct.
How long have y'all been married?
28 years.
Okay. 28 years. And so you are living with Susan. Is that correct?
Correct.
And you've talked to Tammy, your daughter as well. Is that correct? And Tammy is applying to be the guardian. Has she talked to you about that?
Yes, she has.
Okay. And so you've received notice of the application for guardian. Is that correct?
Correct.
And do you have any objection to her serving as the guardian for your wife?
No.
Okay. Do you believe that she is suitable to be your wife's guardian?
Yes, I do.
Okay. And so do you have anything else you'd like to say to the judge regarding that?
No, sir.
Okay. All right, then, Judge, I'll pass this witness.
I have no questions, Judge.
Okay, thank you. And Mr. Malloy, thank you very much for testifying. Thank you very much.
Thank you, Your Honor.
All right, Mr. Norman, anything further?
Judge, I believe Mr. Hammit intends to call his client, so I will rest and close at this time, letting him do that.
All right, we'll see. All right, Mr. Norman, do you wish to bring forth any witnesses?
Mr. Hammit, I believe you mean?
I said, I'm sorry, did I say Mr. Norman? Mr. Hammond, do you wish to bring forth any witnesses?
Judge, if I could just get Mr. Norman to slide the camera over to Ms. Malloy, I may just ask her without placing her under oath if there's anything that she would like to add. And if there is, then we can have her testify. If not, then I'll rest.
Okay.
Fair enough.
Can you see her, Ryan? I believe I'm on her. Okay.
Yeah,
Hi, Susan. How are you?
I'm fine.
Good. Did I cover everything that you wanted to cover, or are there other things that you want the judge to know? And if so, we can have you placed under oath and testify.
I have a couple questions, and just because I'm still trying to learn all this stuff. So,
well, I can answer questions, but we can do that after we get through with the hearing. So if there's anything else that you need to add, then we can place you under oath. Can I just answer those after we're finished? Is that okay, Susan?
I think so.
Perfect. Then I don't have any witnesses, Judge, and we will rest.
All right, thank you. Mr. Hammett, do you wish to make a closing statement?
Judge, I'll just be really brief. I have visited with Ms. Malloy quite extensively about this guardianship at her residence, and I think that the court can gather from the testimony that I listed from the proposed guardian that her primary concerns were that she continue to be involved in the decision-making process, and it sounds like the guardian is certainly willing to do that. So as far as I know, Ms. Malloy doesn't have any objections to the guardianship itself, and I will, of course, assist her in answering any questions that she may have about how the process will work. The only other issue that I know of that I would address is that of the bond, and I believe that Ms. Worf indicated in her court investigator's report that she recommended $150,000 bond, and I certainly think that that would be sufficient to protect the estate, and I will defer, as I do in a lot of instances, to her sound judgment in determining the bond amounts.
Yeah, you and I are in that same boat, Mr. Hammit. Thank you. All right, Mr. Norman, you wish to make a closing statement?
Judge, I just ask that you appoint my client as the guardian of the person and estate. If you would like to wait until you get that background check back, that's why I had not submitted the order yet, just to make sure there wasn't anything I needed to add there. Certainly understand that. However, I do not anticipate that presenting any issues. Regarding the bond amount, we can certainly check those bank accounts one more time and then submit, if you want us to either submit the amount there, submit a statement, something along those lines, just so that we can get a true and correct amount for the bond. And I can certainly have Ryan approve it or Ashley approve it, or however we want to do that. I guess my only question would be that since it is a community interest and she has a 1/2 estate, would we not cut the amount in half for her bond, or would we just bond to the entire account amount since she would have access? I'm not entirely sure how we're going to handle that, if we're going to be expected to partition the account, or I guess what the easiest way would be.
Well, I think in this instant case, Mr. Norman, we bond to the amount that she would have access to.
Okay.
And even though it is a joint account, she almost steps into the role as the community manager.
Okay.
In this case.
And so then we'll just essentially put that all to where she is in charge of those funds, since it is going to be difficult to divide them out, and then just bond to the full amount of that plus the income of the 12 months. Is that correct?
I think that would be
Okay.
roughly correct.
And I think that'll also
and
help.
as to the issue of the of the fingerprint, the court will accept the testimony. Of course, if something does come back, the court
Sure.
can always do something different, and she's going to be in a lot more trouble.
That's right. It'll be a very awkward phone call, I assure you.
Yeah, it sure will be. But we're willing to go forward. All right. Thank you both very much.
Air Force gave me a TS NATO, so I think I'm okay.
That's good. Glad to hear.
Court's pretty confident. All right, Ms. Wharf, as attorney, as the court investigator, I know I've read your report. Thank you very much. Lot of things to kind of unpack on this one. But have you heard anything, or did you come across anything since you filed your report that you wish to change or alter what you've written?
No, Your Honor, and I did, I mean, as you just stated, estimate the bond based on what Ms. Paredes would have access to. And so I did consider the community aspects, but I did think it would be very difficult to sever those assets. So that's where that recommendation came from. You know, I personally feel like a bond can be an estimate. I don't know that it has to be down to $1 as far as what is in the account. So I'm comfortable with you ordering the bond today, you know, even without an exact bank accounting of what's in the account.
Well, I would say, and Mr. Norman, I'm actually going to look at you on this one. The bond, as you know, is an insurance policy.
Yes, sir.
And if we set it at 150 and the estate comes back substantially more or substantially less, it's to your client's benefit one way or another to get that changed. So I'll just kind of leave that up to you and your client as you go through the assets and kind of get those marshaled and to find that out. But
Okay.
you understand the purpose of the bond is not punishment, it's protection.
Certainly.
So
Yes,
I
sir.
just want to make sure, we're bonding enough, Ms. Paredes, that you are protected. That's the whole key to this. Okay.
And
All right.
when we came up with this amount, she did pull up the bank account statement. I believe that was where we got it from. And so it was approximately 106 in the bank account, and then 50,000 in income. And then we just basically called it 160 for any sort of personal effects, adding up to approximately 4,000. So
Well, I know there's jewelry and other kind of things that could, I mean, if we get into all that,
Sure.
and you will need to provide an accounting,
An account and
an appraisal.
inventory.
Yep. We'll certainly do that.
You'll need to get that all inventoried as well. Okay. Thank you all very much. Thank you. All right. After considering the evidence and the arguments of counsel, the court finds first by a preponderance of the evidence that the court indeed has venue in this case because the proposed ward, Susan Lynn Malloy, is a resident of Lubbock County, and that the person to be appointed guardian is eligible to act as guardian and is the proper person to act as a guardian, and that the proposed ward is totally without capacity to care for herself or to manage her property. The court also finds by clear and convincing evidence that alternatives to guardianship that would have avoided the need for the appointment of a guardian have been considered and are determined not to be feasible, and that supports and services that are available to the proposed ward that would have also avoided the need for the appointment of a guardian have been considered and are also determined not to be feasible. It is in the proposed ward's best interest to have this court appoint a person as the proposed ward's guardian. The proposed ward's rights and property will be protected by the appointment of a guardian. The court further finds, based on testimony, that the criminal history of the applicant has been considered. And based on the testimony, the applicant is not disqualified to serve as guardian. Therefore, it is the order of the court that Susan Lynn Malloy is an incapacitated person and that the applicant, Tammy Lynn Predis, is now hereby appointed as the guardian of the person and estate. The court further finds that the powers to be exercised by the guardian will include all of the powers and authorities granted to guardian under the Texas Estates Code. Now, Ms. Predis, you heard us with a lengthy discussion about a bond, and so we do require all guardians to file a bond and to secure performance. I will require you to post a bond in the amount of $150,000. This is payable to the clerk of the court. So whenever you and Mr. Norman's going to,
I'll go ahead and fill that in on the order so that you don't have to remember whenever that comes in.
Okay, thank you very much. Ms. Predis, I need to talk to you just a brief second, but before we do, Mr. Norman, can I talk to Ms. Malloy real quick? Is that okay?
Absolutely. This computer's light. I can move it around.
Okay.
Here we go.
Hi.
Ms. Malloy, hi. You and I didn't get a chance to talk, and I just wanted to tell you a couple of things. One is that I like what you're doing here today in letting your daughter help you take care of yourself, and for your husband too. So this kind of goes both ways as well. And I just wanted to just say thank you to you, and thank you for the honor that I've had today to help your family.
Thank you.
And I just wanted you to know that I really do appreciate you, and I wish you nothing but the best. And I'm hopeful that your time, however long that is, I mean, none of us are guaranteed tomorrow, you know that. But as long as you're around, that you have a life filled with joy, with happiness. I know I saw where you had just recently gone on vacation. I hope you get to do that a lot. And you stop calling it vacation and just start calling it trips, you know, that you do get to go and enjoy your life. That's what I'm very hopeful for, okay?
Thank you.
All right, you're welcome. All right, thank you, Mr. Norman.
Thank you.
Certainly.
All right, Ms. Predis. Would you pronounce that again for me, please?
Predis. If you pray this 10 times fast, it'll come out right.
Predis. I'm a professional name pronouncer. I just want to make sure I get it right. So Ms. Predis. I just need to go over a few things with you as a guardian and what your duties are as a guardian. So now you have the legal duty to provide the food, clothing, shelter, everything, medical care that for your mom. Now, what that duty means is as long as her resources will permit. Okay.
Correct.
So, plus, as guardian of the estate, you are what we call a fiduciary, and I know you're familiar with that term. It would just very simply means you have to take care of her property better than you take care of your own. So what you could do with your property is just anything you want. You can't do that with Miss Malloy's. You have to take care of that way better than you take care of your own. And she has made some of her wishes known as far as participating in the management of her property. And I'll just encourage you that to listen to her wishes and to take those into deep consideration as you manage her property. Okay.
Okay.
And I know you will. I'm not worried about that, but I just want that reiterated as well, so that Miss Malloy can hear that and that you can hear that too. Okay.
Okay.
All right. So, food, clothing, shelter, medical care is all you're the final say in all that from this point forward. I want to talk to you real quick about address. I know that she's had a couple of address changes, she and your dad. Anytime that there is an address change, you must now notify the court. So you must let us know anytime there is an address change.
Okay.
And Mr. Norman pointed out that you cannot commit her to a mental institution. You do not have the right to do that. But you can assist and help her in making her residence decisions. But anytime that those change, you must notify the court. Also, your residence too, wherever you're living. If for some reason you move, you do need to notify the court. We always need to know where you're living. We always need to know where Miss Malloy is living as well.
Okay.
So make sure you are constantly in contact with the court on any address changes that you make. I want to remind you of two items that are due annually. One of them is called an annual report. One of them is called an annual accounting. Now, these two documents are due every year. That's kind of why we call them annual. But what they are is the report is how she is doing, how Miss Malloy is doing. This is the report of the person. Since you're being appointed for person and estate, this one's the report for the person. It's a very simple, it probably takes about 15 minutes to fill out. But that is due every year, along with the annual accounting. You're going to have to account for her estate on a year-to-year basis. Now that is due by this time, June the 20th, every year. And it has that the dual purpose. One is it lets us know how everything's going. Plus also, as a reminder, your guardianship letters are only good for 12 months. They're going to expire a year from now. Now, in order for those guardianship letters to be renewed, you have to submit the annual report and the annual accounting. And once that is approved by the court, then your guardianship letters are renewed for the next 12 months. So that's why it's very, very important that you get those annual reports and annual accountings in. Okay.
Okay.
For as long as you're the guardian of Miss Malloy, you'll have to do that every year. Usually, I think of things regarding holidays. I don't know why I do. That's just kind of the way my brain works. But if it's the 4th of July, Independence Day, you might want to think, oh, hey, that's one of my annual reports, Happy 4th of July. Here's the annual reports. Okay. So that might be a good way to think about it. There's no harm in getting it in a couple of weeks early. Let's just
okay.
Okay. All right. Do you have any questions about any of this?
I can always answer these later.
Yeah. Okay. Yeah. Because I wonder about the inventory and how detailed.
That. Sure.
Okay.
Yeah. Mr. Norman's going to walk you through this process.
Okay.
All right.
Great.
All right. Thank you very much. All right, Mr. Hammit. I know there's still probably a couple of little pressing issues left to do, including approving of the order. And pending that, you are discharged as your duties as ad litem. Thank you very much for your service.
Yes,
thank you. Ms. Wharf, thank you. As always, I don't think I could have made it through this hearing without your investigative report. Very insightful, and it answered a lot of questions that I have. So thank you very much for your service. to this court, certainly for your service to the people of Lubbock County. It's impeccable.
Thank
And
you.
I know I brag on you a lot. I don't brag on you enough. But let me tell you, the people all over the state of Texas know who you are.
Thank you.
Everywhere I
Does
go.
that make her a notoriously bad person?
No, it's
come up with
notoriously
Good.
notoriously good. Okay, I'm not, it sounds
She's-
like an oxymoron, but I'll take
no.
it.
She's the infamous Ashley Ward. Not infamous.
I feel like that's also bad, Judge.
Infamous.
Infamous.
It means really, really famous.
There
I
you go.
appreciate you guys very much. Thank you all very much. Ms. Pratis, good luck to you. And
Thank
if you need anything further from the court, please let us know.
Thank you, Your Honor.
With that, we are dismissed. Time to go eat some food truck.
Go get your sandwich. There you go.
Get that adult grilled cheese.
That's right. Thank you, Judge.
Yes. Yeah, the fancy
Grilled
game.
cheese. That's right. All right. Thank you, Judge.